Let's go ahead and call Mr. Cooper while we're waiting. All right, this is State of Florida versus Stephen Allen Cooper, case number 19 CF 866. Mr. Cooper's before the court today. He represents himself. Mr. Cooper, do you still wish to represent yourself?
Yes, Your Honor.
All right, there's been a bunch of motions filed today, but print out the motion that I've denied, most of the pro se, the ones that were filed as of the 12th. Madam Clerk. Dismissed, the motion to dismiss defendant's motion to reinstate bond and vacate related bond forfeiture and notice of speedy trial.
Development resubmitted.
Yeah, and I'm going to deny them again. All right, where we at? I dismissed the pro se notice of speedy trial demand. But okay, we'll set it for the November. Anything else, Mr. Cooper?
Yes, you dismissed them because of a certificate of service, and they were refiled with a proper certificate of service.
They were just refiled today, and I have not had a chance to look at them. So I won't deny them today. I'll just reserve on that. Okay. I can't. I just have not. They were not in the court file when I looked this morning. They were filed today, so I'm not prepared to order them. I will not dismiss them today, but I will have a chance to look at them. Okay.
So I have a right to reinstate bond.
No, I'm not reinstating it right now, and I'm not going to reinstate your bond. You failed to appear. Judge Costello, my understanding that Judge Costello was covering for me, that you appear by Zoom, and you did not come to trial as you were ordered to, so you're not getting back out of jail.
It was not willingly, though.
You're not getting out of jail, Mr. Cooper.
But I have a right to bond.
Denied. All right, well, denied.
I do have a motion that I'd like to submit to you.
You can submit it.
Disqualification of judge.
Okay, submit it.
Who should I hand it to?
To the clerk. We'll set that for the 19th. We'll have a chance to look at the other ones, okay? That's Friday morning.
Before we jump into today's courtroom chaos, buckle up because this video delivers to very different examples of what happens when people decide the rules simply don't apply to them. In our first case, we're revisiting Stephen Cooper, a defendant who somehow thought repeatedly ignoring court orders was a winning legal strategy. If you've seen his previous appearances, you already know this story involves missed court dates, Zoom appearances when he was ordered to appear in person, and a bench warrant that eventually caught up with him. Now he's sitting behind bars and trying to convince a judge to give him yet another chance. The big question is, can someone repeatedly ignore the court and then expect the court to trust them again? But that's only half the story. Later, we're heading into a courtroom showdown featuring an American state national, a variation of the sovereign citizen movement that believes ordinary laws somehow don't apply to them. If you've never heard these arguments before, prepare yourself. We're going to hear claims about copyrighted names, foreign sovereign immunity, alternative jurisdictions, and even arguments that entire courts supposedly don't exist anymore. The problem for our courtroom philosopher is that he's standing in front of a judge who has heard these arguments before and knows exactly how to deal with them. As you watch, pay attention to a common theme running through both hearings. Whether it's refusing to appear in court or insisting that traffic laws don't apply to you, both cases revolve around one simple issue. What happens when personal beliefs collide with legal reality? The answers are sometimes frustrating, sometimes hilarious, and occasionally shocking. Stay until the end because the judge's response in the second case perfectly summarizes why these internet legal theories continue to fail in real courtrooms.
This is State of Florida versus Stephen Allen Cooper, case number 19 CF 866. Mr. Cooper is present in the courtroom. He's representing himself. Mr. Cooper, do you wish to continue to represent yourself?
Yes, Your Honor.
And we're set for trial November 3rd. All right. Did you get the order to deny motion for disqualification of judge?
I have not received that.
All right, I'll have that printed out for you. There's some other motions that you filed. Looks like we got them yesterday. What I'm going to do is I'm going to leave this on the trial docket for that November date. I'm going to set this for October 24th for a trial management and motion day.
I got the bond reinstatement that was previously filed, and then
Yeah, I'm going to deny that motion for bond. You're based on your failure to appear. I'd already, and for the record, I have had you arrested at least once on a failure to appear, released you again on, allowed you to go back to, I believe, Ocala. On the morning of trial, after you filed a demand for speedy, you failed to appear, and Judge Costello revoked your bond at that time, had a capias, and then we had to, I think the capias was outstanding for a while. So my motion is denied.
I'm prepared to make arguments in regards to that.
But I'm not prepared to listen to them. I'm ruling on your motion. Okay?
What
And
about
I can rule on a motion without hearing argument, and that's what I'm doing today. Anything else?
any of the other motions?
I'm gonna hear everything on the 24th, because you just filed a bunch yesterday on the 16th, and we got them in the court file. So I'll hear everything the 24th. That will conclude today's hearing. Mr. Cooper, we'll see you then. Mr. Cooper, you're here today on your trial management. I believe you're set for trial November 3rd at 8:30. You're representing yourself. Do you wish to have an attorney appointed to represent you or talk any more about that?
No.
Okay. All right. Where are we at?
I believe it's the motions, and I have my motion to reinstate bond. And
That'll be denied.
all the motions filed on the 14th that you postponed 30 days until this date, and none of them have been responded to.
Filed a traverse, responding to his multiple motions to dismiss, the motion for discharge, and the motion to quash the information.
All right.
Actually, a motion to disqualify the judge was filed as well. I believe you got that.
I think I've ruled on that, hadn't I?
I believe you got another one.
Yeah. All right. I'll get you an order of that next week. We'll leave it on the docket for November 3rd. See you then.
Are you going to give me the traverse? 'Cause I haven't received anything.
Yeah, if you don't have it, the state had this already been filed, so if you want to give it to them, the state, the clerk's office can give it to them.
Point. Judge Clark has already seen enough. Notice how calm and direct the judge remains throughout the exchange. There is no yelling, no dramatic courtroom. Key fact has already been established. Mr. Cooper failed to appear when ordered. Its perspective, the Once that happens, convincing a judge to reinstate bond becomes an uphill battle. What makes this situation particularly difficult for Cooper is that judges place enormous value on compliance. Courts can work with mistakes, misunderstandings, and even legal disagreements. What they struggle to work with is a defendant who repeatedly demonstrates that court orders are optional. Every request Cooper makes is now viewed through the lens of his previous conduct. That's why his arguments about rights and procedural issues aren't getting much traction. The judge isn't focused on what Cooper says he'll do in the future. He's focused on what Cooper already did in the past. And from the judge's perspective, that history speaks louder than any motion currently sitting on the docket.
The first matter, Amos Canzoni, come on up and have a seat if you would. Go ahead and have a seat, sure. There's no contract. You and I have no contract. We resolve it in this way. It's a civil infraction, which means the city has the obligation of going first. Go ahead and have a seat and speak into the, if you're more comfortable standing. No, this isn't the time for questions. This isn't the time for questions. What we do here, this is not, we do it in a certain order. The first thing we do is, as you were cited for 2 infractions, is as I read what the officer said, until there's nothing before me, until we have the officer's statement. Once we have the officer's statement, then you can present whatever argument you want. That's the time you make your argument.
So what is it called today?
Pardon?
What are you planning on doing today?
Well, you're defending yourself against the issuance of 2 infractions.
No, I'm not the defendant.
Well,
Defendant, would you agree with me?
you're whatever you want to call yourself, a defendant, a respondent. You're the person who was issued the citations.
That's the problem. That's not the defendant.
I've read the argument. You're not raising it at the right time. Raise the argument after I've read the officer's statement into the record.
I have actually contested that statement on the return service that you received in the file.
Okay.
Statement is not accurate.
If it's not accurate, now is not the time. We don't have the statement yet. I need to read the statement. On January 2nd, 2025, at approximately 1600 hours, while on patrol within the city limits of Yelm in a marked patrol vehicle when I observed a silver Buick traveling east on Mossman Avenue with Washington registration ACA 8168. The registration showed expired as of 11/24. I conducted a traffic stop using my emergency lights. The driver was identified as Amos Canzoni by his Washington State driver's license. Amos first gave me a random card stating he was an American citizen and did not need a driver's license. Amos attempted to argue his sovereign citizenship and that he did not need a driver's license. Amos was unable to provide me with current proof of insurance and stated he did not have any at this time. Amos was given the opportunity to contact the valid driver who was unable to do so. I advised Amos that his vehicle would be impounded. Amos was given a criminal citation for driving while license suspended in the 3rd degree, a traffic citation for no insurance, and a copy of the TOFR. Amos was given a courtesy to his residence. The vehicle was impounded from the scene by Wharton Towing. That's what the officer said. Now I'll listen to you.
Okay.
Now's the time.